Well, yes, I have a lot of people that come to me bringing me things when they don't understand what it is they've received, but their gut, something feels really off or wrong, and they know that they can approach me to say, well, what do you think? What do you think this is? How should we think about this? What should we look into? And that's because of my extensive experience, in all four directions, with people having to deal with, self-government negotiations, land claims negotiations, litigation, all of which they didn't even realize was underway. No one asked them. And so they know, of course, that my being former in-house Crown legal counsel for the Department of Indian and Northern Affairs, as it then was, and that my experience as a Crown lawyer was dedicated to areas like fiduciary duty, treaties, land claims, specific claims. I spent time seconded to specific claims west and provided legal advice on specific claims, for example. I also, at one point, for a period of time, was the only Canadian representative at the Nishka land claims negotiations. And that was during especially a focus on self-government. Now, while I can't share the specifics of, solicitor-client privilege, it says that if Canada is going to rely on one person when there's typically 50 people around the table, including many lawyers, and felt that I could handle that. In fact, we made incredible progress, I might add, while I was there. The other parties wanted me to keep on in that kind of role. You select someone who is considered to have a lot of experience in that area. So in terms of, and I'm really always very keen. I love the law, right? As a lawyer, I practiced for 10 years. Always need to know what I'm doing. I have never been one who just repeats what some other lawyer has done. So when I was moved from Revenue Canada, Customs, Taxation, and Excise over to Indian Affairs file, well, this was all new. So I really prepared myself. I delved into things. And quite frankly, I went through a bit of a personal crisis because, 8-9 years of university, all my experiences, I'd never heard of this stuff. And appreciate, in order for me to be able to bring myself up to speed, I have access to stuff that you don't get in universities, that you don't get just out in the public domain. This is all confidential, information. So you can't take away from my head what I came to know and learn and understand. And there was a time, in the early, sort of turn of the century, where many lawyers understood this stuff. But then, of course, we know that lawyers were prohibited, risking, prison if they were to have clients retained dealing with these issues. So the way law works is, especially back in those earlier times, the senior lawyers train the junior lawyers. The senior lawyers pass on their knowledge and expertise in how to do these things. But if there's no money to be made, why would you do that anymore? So it cut off. So not only did residential schools cut off the knowledge that the Indigenous side understood about who they are, what they have, what they own, what their laws are, there was also this effort on the non-Indigenous side to say, well, lawyers will be taught something new, forget the old stuff about these are really treaties, that type of thing. And we'll go on to how we'll shape them to think about all of this in more a domestic role. So I'm probably the unique person who has had access to all of that. As well, I've been brought in by elders, now ancestors, and shown, not just reading about or asking my grandmother, I've been shown the operations of Indigenous governance, Indigenous nations. I've been brought in and made commitments to protect in ceremony that's, over 2,000 years old, that no white person has ever even seen or knew existed. But they protected those ceremonies, their laws, their governance. They protected all of that in a very careful way. So I'm, I understand how provinces work. I've provided advice to Northwest Territories. So I've been around all of this. It's pretty hard to fool me in terms of what's actually being done. And why? Because Canada just can't wing things. Provinces and the federal government, they can't just do what they might want to do, like you or me as an individual can make choices. They are bound by things like what's the established practice and policy? How can we approach things? And currently, there's really only 3 ways that Canada can negotiate anything. And one is when there's been a specific claim submitted, and that's done only, that's a matter of policy, part of the land claims policy, that can only be done by a chief and council for a band. There's no provincial party. And if that thing goes through to settlement, then involved in that is you're releasing everything, and the people have to vote because it's a surrender. Most times in those specific claims, those lands are still reserve lands, or they've been unlawfully taken, so they're not valid in law. So those specific claims are aimed to make it lawful, so that everybody whose interests built upon that now have a sturdy foundation, if you will. But there's no province involved. And then you have litigation, which obviously can be settled between the parties or among the parties. That doesn't require any vote by the people either, by Indigenous people, because it's only a matter of who's starting that litigation, who the parties of the litigation are. Class action, different, because the judge plays a protective role there, and still no vote to the people, but the judge will decide, is that fair compensation? This is a good, decent settlement. Then we have the biggie, that is so busy underway, but it's like a swear word. It's a dirty word, land claim, final land claim settlement. So the mythology is to call it, it's a modern day treaty, and it's something unique. Everything's unique. Well, Canada's not out there doing one-ofs all over the place. What's unique is this is a particular band or tribal council or whatever body of Indians, the body of Aboriginal group, they call it. Whoever approaches Canada and says, we want to do this deal. Okay, sure. There's nothing in any of that says, how do we do this in accordance with, to make it lawful in accordance with the governing laws of the people themselves. So the peoples are kept out. And this Manitoulin Project that was brought to my attention not long ago is one of these desperately, we won't call it impacting treaties, we won't call it a land claim. It's just something unique and different in an out-of-court settlement. Well, yeah, technically, yeah, it's an out-of-court settlement, but can we please have the statement of claim? Can we see everything? But anyhow, so giving you an idea of not only my background, but why people come to me is because I can kind of surf through all this, and even through a muddle of crap designed to either get people disinterested. Oh, I can't understand that. Well, I can't either. Some of the stuff I've got with all my background in digging through it, I don't know what they're trying to say. And there is no reason for that, right? I could craft a 1-pager saying clearly what's been underway, where we're at, and what's left to do, and why we're contacting you or filling you in now. There's very easy ways to do this, but it suggests that these efforts to get it in place, who can understand when it's not aligning with what the reality is, with what the provinces can do or not do, what Canada, the feds can do and not do, and where are the people in all this. This big effort to cut the people out is why so many people are saying, Janice, do you know what's going on here? Because no one's telling them. Now, it shouldn't be my role, but I am very well suited and positioned in order to say, here's what it looks like. And then, to go further to help them to not panic about it, and say, where do we go from here? How do we protect ourselves? Because we don't want to do that. We never said we wanted to do that. But yet you have, one case, a recent thing just came to me, 3 men saying, that basically there's no nations, there's no treaties, it's like, wow. So how to think about that? Yeah, I've been all over the place in terms of the various parties, so I know how they think, how they approach it, what their limits are. And that goes in terms of companies too, trying to do things. Where's their so-called certainty? Well, it's not relying on all this stuff that's happening. That's just trying to band-aid and make everything look nice, but it's not. And ultimately, it's going to cause us so many more problems down the road, is my prediction. This isn't an area where I have in the past done a really deep dive, but of course, recently I have looked more intensely to what that background is. You have to in order to be able to try to figure out what's being done or attempted. Now, the really cool thing about this area is that the entire island was seen and dealt with as continuing original jurisdiction. In other words, no interferences with in any purported sale or distribution of land in any way. And what's really cool is that when the Crown wanted to bring in, say, look, hey, is it okay if we bring some other Indians in from other parts that don't normally reside here? So the fact that they're having to, and that's the first treaty there, having to ask permission to say, would it be all right if we directed them to come stay with you from these other areas? And so that was essentially it's a treaty, yes, but there's absolutely no surrender, if you will, or sale of land. It's just, hey, would it be all right? And those permissions were granted. Now we have the next step, the treaty number 94. There's a lot of discussion about whether that was validly put in place in accordance, for instance, with Anishinaabe law. Apart from that issue, though, what's really cool about that whole document is that, again, the Crown was not, if we assume for the moment that it's a legitimate document, and I often think that people, well, there's aspects of that document that, like I said, this is a whole, people do dissertations for university classes on this, right? So leaving apart that, was this something that was lawfully done? The fact is that written in there are these words, to have and to hold. So the treaty itself is not a sale of land. Even though Canada will say, well, this is a surrender treaty, it is not actually okay, here's our land, we're just part of Canada now. Not in the least. It actually recognizes their sovereignty. That sovereignty is not limited by the border between Canada and US. It acknowledges from that first treaty that you have the right to determine who is among you. Whether you bring them in as nationals of your nation or not, that's your business, not ours. We just want to bring them to you if that's all right. But in this second one, where all the controversy is, it's saying, okay, well, you can sell all these lots and you can sell all these things. And then litigation has been brought, and this land claim process is involving that, oh, well, yeah, that was all fine, but you just didn't pay us what we were owed and things like that. There's a lot of details there that instead of exploring them in a good way, I believe, based on what I've read, coming from the parties involved, that they're just trying to, let's just roll that up. In other words, because every final land claim settlement, as part of that, you release all the previous wrongdoing. And because you're terminating as an entity, becoming a new legal entity under Canada, and all of the other things, none of that carries on. And there's a specific release to say, basically, that was all fine. There was no wrongdoing done. So principally, that's a difficult aspect of this. When the communication says there's 5,589, I think it is, lots that are unaccounted for, that were sold and there was monies owed, that that's a lot of lots. You don't have to give up your nationhood. You don't have to give up your ownership, underlying title ownership, in order to get what's owed you. But obviously, Canada always loves to make it look like you're getting something in terms of the Indigenous people, but actually Canada's benefiting and getting things for cheap. It's a sale, basically, for a whole lot less than what normally would happen if you were to handle those lot issues separately. It's a maybe quick and easy way to do things, but it does not, the people, when they've not been brought along with this and said, yeah, this is the way we want to go, and all this has been negotiated for I don't know how many years, that's not going to bring peace to the area at all. No one's going to accept that as legitimate, except maybe the 5 or 6 chiefs who have directed the process in the tribal council. Well, there always has been an Aboriginal industry. When I left the Department of Justice, I was being slapped on the back and saying, oh, smart. Well, the only area of law in Canada that was growing. All the other lawyers, all their business areas, fields of practice were all diminishing. And that was back in early 90s. And the kind of industry we're seeing here, well, yeah, I mean, lawyers in this field are not, in my view, the definition of professionals. Lawyers are supposed to be professionals, which means you can't just treat it like a business. You have to actually protect your clients. You have to do certain things that they can't do for themselves. But what we've had in concert with lawyers wanting to make the money, and like, for instance, this lawsuit in Manitoba that attacks Treaty 1, they're saying we want $11 trillion in damages, or whatever you think. But I mean, they're stating this is what it's worth. Well, who's asking for this? One old Indian, right? One Indigenous old man who maybe is an elder, maybe not. I can't call him an elder based on what I've read there, but he may well be, and he may well have just been taken advantage of by the 2 male lawyers who are pushing this, right? And when you've got people in poverty and desperate and and they don't know what to do, right? Why would they? How would they? They've been, the quality of education in residential school, what they've been put through, the oppression, and then their own lawyers being trained to view them much differently than how, when I sat with the leaders, in the back when would talk about it. They don't have those tools. They don't have that background knowledge. The lawyers come out, they're held out as being the experts. They're knowledgeable. And you have to understand that, especially when, like in that particular situation I'm talking about, that's got me kind of riled, an older white man, basically, they know how to control, right? I've sat in meetings where they act like the Indian agent of old times, and they even look that way. So when you put someone like that who basically tells them what to do, as opposed to someone like me who says, look, you have a big decision to make. I'm going to tell you about what's involved. If you make this kind of decision, this is where it goes. You make this kind of decision, this is where it goes. Do you want money? Do you want nation life? Do you want your future generations being able to rely on the land to provide for them in various ways that work in those times? Or do you want to cash out now? But everyone is trying to fool people to say, oh, you're not cashing out. You're just getting what's owed you, and everything will be fine for the future generations. Well, that's just not so. You read the language. You read what Canadian courts have put in place, what the policies are, what's in these documents. Like, for instance, this particular lawsuit that basically opens with, there's no nation, there's no treaty, but this is owed. Well, why do you even have to have that in there? You don't. You could still pursue these things, but why are those things in? Because the lawyers have to come up with a way to say why their client has standing, why they can put this to the courts, why they can speak on this, because they don't have any authority to do that. under the nations, under the Indigenous law. They don't have it. So it's manufactured. And you see all that, but yet people don't know what everyone else is doing. So yes, it's an industry. Lawyers make their money off stuff. Everything that, for example, was created in the West Coast where there are no treaties has been dog and pony showed across to else towards the East where there are treaties and longstanding relationships that you can point to that says, yeah, the Crown specifically recognized your sovereignty. So why today would individuals say, oh no, that died sometime, and I don't think that the people that are being used really know that's what they're saying, because it's coming through the lawyers. Now, Canada is really happy to let this all happen. So when, for example, there's a statement of facts that says on behalf of everyone, Manitoulin Island, for example, or Treaty 1, for example, Canada's not going to contest that. They're going to say, oh, that's great. Thank you. Right. So the policies are set up to make it easy to start something up, because ultimately Canada knows that they're going to get what Canada's always wanted, more than what the Crown was given. And that's all part of Canada's aggressive self-government agenda for itself. Most of Canada took down governance functions, not by being granted by the Crown, but rather just doing it. And the Crown saying, yeah, that's okay, that's cool. So it's been such a successful approach for Canadian governments that now they're doing it with Indigenous nations. Why? Because they know the people as a whole never let these things happen. So you have to get rid of the role of the people, so that you can have one older gentleman being convinced that you can save everyone and you can get a whole lot of money for everyone if you just do this. And you know what? We'll just take a commission. We'll take a cut. We'll take 30%, 40% off the top. And lawyers keep making a lot of money, and they really don't have to take into consideration the protection of the nations. They only have to act for their client. And in terms of land claims, for example, you have in certain areas law societies saying, well, you can only take instructions from chief and council. Begging the question is that when tribal councils are doing these things, how are lawyers able to allow that to happen? Right? It's a very, we'll look the other way when it serves the function of getting a final solution in place. But if you've got someone who's actually trying to protect the nations and do the proper diplomacy and rely on the actual relationships, we better put something in place that won't let that happen. So, for example, when I was a Crown lawyer, a way to approach many things would be initiated by petition. The people would speak and draw attention to wrongdoing, not chief and council. Very rarely. They might have, as individuals, signed into that, but it wasn't a BCR, Band Council resolution, saying, hey, this is happening. It was the people. And so coming out and helping the people to present their issues and the diplomacy necessary that's outstanding, suddenly law society is like, oh, we can't have our lawyers doing that, even though this is the way for hundreds of years. And it's exactly how I was taught, to look at things. Otherwise, those petitions would have been ignored, right? So I knew exactly how a lawyer could act outside of government in terms of this kind of unique client, which is a collective client. But lawyers, law societies say, no, we can't have that, right? So law societies, lawyers, governments, and also now universities, sadly, is all part of it. And there's lots of money to be made. And speaking of money, that's the other thing. People hear these amounts, they actually think, because I'm like, how? They actually think they're going to get a cut of that. They never see a dime of it. In fact, you look at Frog Lake First Nation. I looked at some of their financials a few years back. $360 million gone, right? the Vancouver method of money laundering, is that in play? A lot of these places where the money's come out and it's gone and the people are saying, well, we don't have anything. Where did it go? What did you spend it on? Oops. And that person's no longer running for chief. Well, they don't need to. Their money's safe offshore somewhere. I don't know specifically about Frog Lake, but this is the kind of thing that can easily be facilitated. I myself was offered a lot of money to just go away, right? So, it's a whole industry. Yeah, well, they're a federal board. Courts have held that, right? So you're absolutely correct. This is not an Indigenous entity. It is an interference, and I say unconstitutional and unlawful interference in their governance, which survives. Why? Because, in treaty areas, the Crown recognized their sovereignty, recognized their governance. Otherwise, there wouldn't be treaties. So, and the governments of the Dominion of Canada are not a party to that. They are bound by it because they only exist as a result of self-governance that has come from the Crown to allow them to function here. So here's how they've been doing it. I noticed a while ago with people bringing me things like membership codes, election codes that they're being asked to vote on. Now, some of them were curious. It's like, we just did this 2 years ago and it's worked. Like, why do we need this? So that always gets me suspicious. What do they not have in place that they need to get in place? And what I found is in all these election codes and new membership codes, there is a purported handing over of power of the people into the hands of either just the chief or the chief and council. And seeing just the chief was new, and also gave me a big red, what's going on here, because you would expect maybe chief and council, but it's like, wait a minute. And why? Because the chief can then roll up the authorities given to the chief by the people through these documents. And you'll find it in just 2 or 3 sentences, buried deep, where no one's going to even read that. They read the first page or two. It's got all this nice language like what you're describing. And they say, oh, okay, they're doing it under our law and our way, and that's our language. This is great. They're not going to read the 30 pages. They're not going to even, if they read this, know what they're reading. But I, of course, do, right? And so they roll in. So they're saying, I've got this covered off now. The people handed over their authorities to decide into the hands of the chief. The chief, in turn, can roll that up to the AFN, Assembly of First Nations. It can roll it up into the FSIN, the various provincial bodies. They're all incorporated bodies. These are all Canadian corporations, either under provincial jurisdiction or under Canadian jurisdiction. The chief can then hand over the authority that they carry, that they say is from the people. People trust me. I can do it all. I have the power now. Then they put it into these corporations, and the corporations then are doing these things. Is this law? This just doesn't work. The only way they make this work is by saying this, and this is what you're seeing in the pleadings in court, is that there is no more nation. There are only these First Nations bands, and they are the successors to what was. In other words, these are the descendants of a nation that doesn't exist anymore. We have this thing, the Indian Act Band Council, who's then rolling up into these other organizations. That's all we have. There is no more nation. There is no more original governance. There is no more Indigenous law. And of course, all this kind of really stepped up when I kept pointing out that law of the land, Indigenous law, still own the land. Everything flows beneath that. So it's like, oh no, the nations have to be dead. So the treaties are dead. And the only thing that exists today are the successors for the ability to collect annuities, for instance, are these Indian Act bands and the tribal councils, which were set up just to deliver services, programs and services, but now they're being used to get a bigger piece of the territory signed off, right? Because you've got in the Manitoulin project, you've got what, six bands that are rolled into that UCCMM tribal council, and they're negotiating. And so what have you got? 6 people, 5 people, a couple of lawyers or a law firm? They don't carry any authorities. So you have to set the stage to say, well, yeah, they do, because that's the only thing that's here now. The nations are dead. The treaty, and having the treaties dead, no sovereignty to worry about. It's all gone. It's all historical. This is today. This is, we're going to do modern land claims agreements. We're going to get all this money. Well, the money goes into their hands, and I guarantee it's not going to last 7 generations, if ever, right? And the one and done, none of this ultimately is going to withstand the test of time. So just like we've had in the past, the Indian agents that did things to get land into their hands, it's really no different today, just on a larger scale. And they purport to have the people agreeing to this. But the people, I can tell you, are busy doing what needs to be done to say, hold on, they didn't carry our authorities. We're still here, right? And that's what's big. It's important to not be using language that mirrors the picture that Canada's trying to create. And that's the most difficult part now, because people will lapse into using terms that are defined in court cases, for instance. And you see all that terminology over all these agreements everywhere that really, like I said, you don't need to have it there. So if it's not necessary, and good lawyers will say, you don't need it, you leave it out. All you're doing is raising potential for problems later. But it's all about that. It's all about getting those representations in place to try to bind future generations. So people like myself and individuals who do know who they are, do know they're still a nation, know their lands and all that stuff, are saying, what can we do? Now, you don't have the multiple millions of dollars that lawyers are earning from this to help you. But this stuff doesn't have to be complicated or that route, right? It's simply a matter of saying, hey, this is who I am. I'm here. This is ours. And under our law, whatever you think they're doing and putting on the table, they have no ability to do that. We're not dead. Our laws aren't dead. Our land is to provide for us for all time. And while under our laws, we also are amenable to sharing and amenable to looking at ways of working together. You can't do what you're doing. You can't just take it. This is a new way of taking things. And, you have the universities busy saying, we've got to make space for Indigenous law. They're trying to assimilate Indigenous law now. Every aspect of nationhood that me in particular have pointed out, you can't get away from this. This exists. Well, then we have to get rid of that. And so you have under reconciliation, which is what? A synonym for assimilation. Yeah, here we go. So we're going to make space, and we're going to, and these lawsuits, right? They talk about all this kind of stuff. If you're pursuing an annuities, why are you talking about, and always has been part of Confederation? What's that got to do with the treaty and outstanding obligations? Nothing. But it is part of this. The lawyer's got to make sure their client can actually have standing in court, that the court will see them, and try to do this. So lawyers, instead of using their creativity to assist legitimate nations in legitimate ways, are doing what they do best, in the sense of manipulating and misleading, and who's to stop them? When the governing bodies, when the Canadian governments want this to happen, and if you look at how tightly our legal law societies are linked with our politics, right? Lawyers in this country are not a standalone check and balance. They are part of the problem. First and foremost, you need to know it's the whole island there, not just certain lots. the fact that the lots get thrown in as part of the settlement, it's the whole thing that is being put on the table. Underlying title, ownership, right? That's what's being put on the table. Whether it's lawful or not, the point is that it appears that we're now at the stage where a final land claim settlement agreement is imminent. And they've worked, we haven't seen it. We don't see any drafts. We don't see anything, right? This is the first time there's been communications to say, well, because we're going to be putting it to a vote in each band, we need to start giving you some information. Because the whole concept is that not only is there a vote, first there has to be enrollment in the new entity, and the enrolled eligible voters will then be able to vote. And that's not necessarily everyone in a band, right? And so you need to give, quote unquote, full information so that you can get a freely decided vote. So they need to start providing information. Now, my whole issue is if you're starting out in such a convoluted and secretive and hidden manner, doesn't bode well, right? Especially when I said you could simply do, by date, right? Here's the statement of claim was filed on this day. If you want a copy, here it is. We've posted it. It's a public document. You file a statement of claim, it's a public document. So put it up in your website if someone wants to look at it. So that, and if that's been settled, some of these apparently have been settled. Well, who is involved in the settlement? Not the people, because they don't seem to know about these things. So let's see what you settled for. Let's see it, right? What was the deal? Was this a settlement so the lawyers could get paid so you could do this stuff? Like, if this was a settlement, it's collective monies. What happened to it? Let's have an accounting, right, of what's to that stage. So they're trying to say and set the stage to be able to satisfy Canada and the province. And keep in mind, they will rely on the representations of these chiefs operating through the tribal council. So the chiefs can be a lot. They're going to get control of all that money. Are they going to lie or not? Are they going to, there's an incentive. There's a clear conflict of interest, right? Both in terms of handling power, handling the money. Who is required to fully inform the people? Not the lawyers. Their duties are just to their client. And when they don't even describe who their clients are or who their client is, you don't know what they owe where. They certainly, I can tell you in all these cases, they don't owe it to the people themselves. So if their client says, we want to do this deal, the lawyer will do what it takes to get that deal done and get paid and rewarded very well for that. When you look at the role of Crown Counsel, it was always my job to protect the people, often against chief and council. Can't tell you how many deals would come by and it was just obvious it was going to go into the pockets of chief and council, and I couldn't approve it. Why? Because I was essentially a lawyer protecting the interests of the people. And in that kind of case, I would go and explain, you can do this yourselves, and get the returns. Why would you hand it over to one person to then control all the dollars, kind of thing? Now, obviously, Canada, and when you're in litigation or when you're in claims, you're in an adversarial kind of role. It's not like what I'm talking about, where there's a Crown lawyer that really has to sign off on, this is okay, this will benefit the people, meets fiduciary duty standards. There is no one here for the people to protect anything. They're literally out on, there's no access to justice. There's no access to independent legal advice. Canada says, oh, well, the chief and counsel had the lawyer. Well, not when the lawyers are not only don't have to protect the people, are specifically told by the law societies, you can't, even if you wanted to. Your duty is to your client, who is this person or persons. So this is why my phone is ringing off the hook all the time. This is why people are coming to me, because I understand those duties, how to fulfill them, and what's needed. But the rest of the world in this environment are saying no. Well, is that ultimately going to stand up to standards of fairness of, this is like they're not humans, right? We're back to doctrine of discovery. Who cares? No one has to protect them. They're loose. They want to do this. They chose, the only thing they're left with is the vote, vote in their chief every 2 years, 4 years, whatever, which often is controlled by a family that puts their delegate in that seat in order to what? Gain control of the money and have a better chance of getting some of it, right? So it is critical for people to understand that scenario. So don't be thinking in these situations that Canada's looking out for you, the province is looking out for you, the lawyers who the tribal council or the band have hired is looking out for you. None of them are. And waiting just to elect in chief and council, that's, if you've handed over purportedly under these documents that you were not informed you were handing it over, so I don't see that as valid. You need to know what you're deciding. There's a couple things that, that can be done. So one, you're very clear on who you are, what you have. The fact you have not delegated your decision-making powers, and that you cannot do that under your laws. The responsibilities rest with the people for a reason. Decision-making is done and yes, it's been interfered with. So you can't just stop and try to get back where you're at 100, 200 years ago. It isn't going to happen because you're in a different place now, different circumstances. But you can clearly say, hold on a minute. No one asked us. We never delegated it. You can't, mislead us and manipulate us into purporting to have given you our authorities. Under our laws, we just can't do that. Under our laws, we just can't give away our land and abandon who we are and such. So there's also, I recommend doing an audit, not a financial audit, but an audit. What do you know your band's been into? What's been signed into? Or what have you heard rumors of have been signed into, and try to find out. You can search some areas to find out if you're in there or not. And then you know where you're at exactly, because there's no one blanket strategy to set the record straight. That's basically what you're doing. You're saying, hold on, no. Okay. And we're not being silent because we don't agree with this. And you can't do this. And so I help people in expressing that correctly. Sadly, too many people, like I said, will use terminology they've heard. And this isn't finger pointing. It's just they don't know how better to express it. And so I'm teaching a lot about how to speak consistent with this. And I really want to encourage people that it's don't give up, right? Don't give. It looks like, oh, they've got all this money, they're doing all these things, and they're going to do all this. And a lot of people are going to vote maybe and think they're going to get a cut of that. They are not. People need to be really clear. Do not expect a dime, but also expect that your grandchildren will not have anything other than begging as a domestic ethnic minority. So some footwork, right?